name's Emily Kyle, and I'm an attorney here at Kyle & Kupaszewski Law Firm. We're located in Scottsdale, Arizona, and people have lots of questions, so I decided I would try to answer those questions. So today we're going to talk about conservatorship. Now I want to be clear, I'm probably not your lawyer, so the information I'm going to provide is very general in nature, and I hope that you will seek the services of a qualified attorney when it's time for you to move forward with a conservatorship proceeding. In Arizona, we call guardianships actions when we are making health or housing decisions about an individual who needs some help and is incapacitated. And we call conservatorships when we need to make financial decisions for that person. In some states, it's guardian of the person and guardian of the property, but we have two separate names for those two separate roles. You can do a proceeding that is both at the same time, guardianship and conservatorship. You can be guardian and conservator, or you could have somebody who's guardian and somebody else who's the conservator. The proceedings do require a live hearing, and your loved one will be served with the papers, meaning that they're going to see the allegations as to what it is that you believe is causing them to be incapacitated at the current time. We also need a health professionals report to explain why it's so hard for them to manage their money. And conservatorships can be complicated and difficult processes. The court needs to know all the money, all the sources of income for that person that you're asking to manage. Additionally, some assets might need to be restricted while you have access to other assets without court approval each time. You most probably will have to qualify for a bond. Bond is basically an insurance policy to ensure that you don't take the money and run off somewhere and you misuse the money that's supposed to be the money for the incapacitated person. You get a bond over assets that are unrestricted, meaning that if I have access to $50,000 and I have a $50,000 bond, if I misuse some money, the bonding company will replace the money that I've misused, and then they'll sue me to get the money back. So don't misuse the money. If you're going to be the conservator, you're in a fiduciary capacity, meaning that your entire job is to look out for the best interests of that person. You're going to have to account for every single penny into the accounts and every single penny out of the account. So making sure you keep good records is really important. And in Arizona, those are annual accountings. In some states, those happen every 2 years, but in Arizona, they happen every year. On top of that, if there's a change in how much you budgeted in a certain category, and you see that you're going to exceed that budget by 10% or $2,000, you have to file an amended budget to explain to the court why it is that you're spending more money than you anticipated. And usually there's a great reason. Care expenses went up, cost of living went up, whatever those expenses are, you just have to lay that out. Maybe the attorney's fees went up because things were contested or got more complicated. Or you had to sell a house and had to get a real estate agent involved to figure out what the title issues were. So it doesn't mean that it's not acceptable. It just means you have to let the court know about it. So conservatorships, as I said, can be complicated, and you want to make sure you're doing things correctly and keeping great records. We're here to help if you need us. Thank you so much for listening. And if you have a different question, send me an email, and maybe you'll see your question on my videos. Thank you so much. Have a great day.